Hello, my name is Adam Freed, and this is my colleague Katie Cownie, and we are partners in the Dorsey and Whitney law firm here in Des Moines. We represent long-term care providers, including nursing facilities and assisted living programs across the state of Iowa. We're here today to talk about the regulation of assisted living programs in the state. So we're going to start out with discussing some of the high-level differences between assisted living programs and nursing facilities. We'll talk about the legal framework for assisted living. We'll discuss tenant rights in the Iowa Code, challenges associated with tenants' rights, some common questions that come up in our practice, and then we'll talk about some additional methods for exercising tenants' rights. We'll talk about guardianships and conservatorships, powers of attorney, resident autonomy, and managed risk. So with that, I'd like to turn it over to Katie to kick us off.
Thanks, Adam. Let's go ahead and discuss the distinctions between assisted living programs, or ALPs, and nursing facilities, as they serve different populations with different care needs. First, assisted living programs, or ALPs, are designed to provide housing and services for tenants in a home-like environment. These services can include health-related care, personal care, and assistance with activities of daily living, or ADLs, such as preparing meals or housekeeping. The focus in ALPs is on self-direction, choice, and independence, while fostering a sense of privacy for the tenant. However, ALPs come with clear care limitations. They are not equipped for continuous nursing care, making them a better fit for individuals who need support, but not round-the-clock medical supervision. In contrast, nursing facilities are structured to meet the needs of individuals requiring 24-hour nursing care. These facilities are suitable for residents who need comprehensive personal health-related services and assistance with activities of daily living, or ADLs, such as eating, bathing, and dressing. What sets nursing facilities apart is their ability to provide continuous nursing care, making them ideal for residents with complex medical needs. This includes individuals who are medically unstable or require maximal assistance with daily tasks. Moving on, level of care. Assisted living programs offer supportive services and limited health-related care, suitable for individuals who require some assistance but not continuous nursing care. In contrast, nursing facilities provide comprehensive medical and nursing care for individuals with significant health needs. Regulatory oversight. While both types of facilities are subject to state regulations, the specific codes and standards differ, reflecting the varying levels of care provided. Assisted living programs adhere to standards outlined in Iowa Code Chapter 231C and Iowa Administrative Code Chapter 69, whereas nursing facilities follow regulations in Iowa Code Chapter 135C and Iowa Administrative Code Chapter 58. Additionally, nursing facilities are regulated federally by CMS. Resident accommodations. Assisted living programs emphasize a home-like environment that promotes independence and personal choice, often providing private or semi-private apartments. Nursing facilities typically offer more institutional settings designed to meet the intensive medical needs of their residents. Adam, I'll go ahead and hand it back over to you.
So additionally, there are some key differences between traditional assisted living and dementia-specific assisted living programs, or memory care. These differences are critical for understanding how care is tailored to meet the specific needs of tenants, especially those living with dementia. First, we're going to talk about the scope of services. Regular assisted living focuses on providing housing with personal and health-related care for tenants who maintain a higher degree of independence. In contrast, dementia-specific assisted living programs are designed to care for tenants with cognitive impairments, such as those in stages 4 through 7 on the global deterioration scale. These programs are specialized to support cognitive and behavioral health. Next, we'll talk about our certification requirements differ. Regular assisted living programs require general certification to operate and provide care. However, dementia-specific programs undergo additional certification, ensuring compliance with enhanced standards that address the needs of individuals with dementia. Safety is a vital area of distinction. Regular assisted living programs include standard safety measures, such as emergency response systems. Dementia-specific programs, however, must implement additional features like door alarms, delayed egress locks, and comprehensive procedures to manage risks of tenant elopement. Finally, there are differences in staff training. Regular assisted living staff must complete basic training in tenant care. For dementia-specific programs, staff must receive a minimum of 8 hours of dementia-specific training upon hire, and direct contact staff must complete an additional 8 hours of annual continuing education to stay informed about the latest care techniques. Iowa Code Section 231C.5 establishes that all assisted living programs must execute a written occupancy agreement with tenants or their legal representatives. This agreement clearly outlines tenant rights and responsibilities, including fees, services, and policies for grievances, transfers, and confidentiality. It mandates transparency regarding third-party payments and prohibits retaliation. The requirement of delivering updates at least 30 days before changes, except in emergencies, ensures tenants are informed and protected. This statute creates a structured legal framework for tenant rights in Iowa assisted living facilities. The Iowa Administrative Code, Section 481-67.3, establishes tenants' rights within assisted living facilities, emphasizing dignity, respect, and autonomy. It ensures tenants have the right to adequate care, confidentiality, freedom from abuse and restraints, and the ability to manage finances or present grievances without fear of reprisal. These provisions create a strong foundation for safeguarding tenants' personal freedoms, privacy, and quality of care within assisted living programs.
Tenants have the right to be treated with respect, maintaining their dignity and autonomy. This includes avoiding patronizing terms like sweetie or darling, and being mindful of language, as verbal mistreatment can constitute abuse. Staff should communicate in a manner that is respectful to each tenant, creating a supportive and professional environment. Tenants are entitled to care, treatment, and services that are adequate and appropriate to meet their individual needs. The Iowa Department of Inspections and Appeals and Licensing serves as the investigator and adjudicator in determining whether the care provided by an assisted living program meets these standards. This ensures oversight and accountability, protecting tenants and maintaining quality care across facilities. Tenants have the right to respect and privacy in their medical care, ensuring their dignity and autonomy are maintained. Personal and medical records are confidential, and their release requires written consent from the tenant, except in cases of legal necessity, transfer to another healthcare facility, or compliance with third-party payment agreements. This protection ensures tenants maintain control over their sensitive information while facilitating necessary communication for their care.
Tenants have the right to live free from mental, physical, or emotional abuse, ensuring their safety and well-being within the assisted living facility. This includes protections against any behavior that may harm or demean them, fostering an environment of respect and care. Tenants have the right to receive timely and reasonable responses to their requests from facility staff and management. This ensures that their concerns, needs, and inquiries are addressed promptly, fostering trust and satisfaction in their living environment. Tenants have the right to freely associate and communicate privately with individuals and groups of their choosing, including tenant advocates. This ensures they can maintain personal relationships and access support networks without interference or restrictions. Facilities must respect this right to foster an environment that promotes social engagement and personal freedom. Tenants also have the right to manage their own financial affairs, preserving their independence and control over personal resources. This right may only be delegated to a legal representative if the tenant chooses or if one has been appointed by law. Facilities must respect this autonomy and ensure tenants have the freedom to handle their financial matters without unnecessary interference. Tenants also have the right to present grievances and recommend changes to program policies or services without fear of retaliation, restraint, or discrimination. This ensures their concerns are heard and addressed in a fair and respectful manner, fostering a supportive living environment. Tenants also have the right to live free from the use of physical or chemical restraints, ensuring their autonomy and dignity are preserved. Restraints cannot be applied as a means of discipline, convenience, or retaliation, and their use must be avoided unless medically justified and properly authorized. This right protects tenants from unnecessary restrictions, promoting a safe and respectful living environment.
A tenant having deficits in cognition is one of the largest challenges in upholding and complying with tenants' rights. There are communication barriers. A tenant with cognitive impairments may struggle to express their needs, preferences, or grievances, making it challenging for staff to provide timely and appropriate responses. Understanding rights. Cognitive deficits can affect the tenant's ability to fully comprehend their rights, including privacy, financial independence, or the implications of giving consent. Decision-making capacity. Cognitive impairment may hinder the tenant's ability to make informed decisions, which could impact their ability to manage finances or understand care options. Grievances and advocacy. Tenants with cognitive deficits may face difficulties in advocating for themselves or navigating grievance procedures without additional support from legal representatives or advocates. A unique aspect of assisted living is supporting tenants as they maintain their independence. This often includes tenants leaving temporarily to go to restaurants, attend church services, or visit family. While this is a routine part of life in a regular assisted living program, additional considerations come into play for tenants in dementia-specific programs. In a regular assisted living program, tenants are typically able to come and go with minimal oversight. These outings are encouraged as they enhance the tenant's independence and quality of life. Staff may assist by coordinating transportation or ensuring tenants have what they need for their outing. For tenants in dementia-specific programs, temporary departures require additional planning to ensure their safety and well-being. Memory care tenants may experience confusion or disorientation, particularly in unfamiliar settings. To manage this, programs often work closely with families to establish clear protocols for outings. In the following slides, we will review what considerations are necessary when a tenant in a dementia-specific program wants to leave an ALP, have an intimate relationship, drink alcohol, or smoke.
So if the senior has a significant cognitive impairment, the senior may not have full legal capacity to make independent decisions, including decisions about leaving a facility. The determination of a person's ability to make informed decisions is based on the individual's capacity to understand and appreciate the consequences of the individual's actions. If the senior has a legal guardian or a designated agent under a durable power of attorney for healthcare, this individual may have the authority to make decisions on his or her own behalf. It is important to check if there is a guardian or a power of attorney in place who has the authority to make decisions about outings. The facility has an obligation to provide appropriate supervision and ensure the safety of residents. The facility may need to assess whether the individual is capable of leaving without endangering their own well-being or the well-being of others. The facility may need to conduct a risk assessment to determine if the individual's cognitive deficits pose a danger to the individual's safety when leaving the premises. If the senior is at risk of getting lost, wandering, or becoming confused, the facility may have specific protocols or policies to follow. Depending on the individual's needs, the individual may require a caregiver, family member, or staff member to accompany or transport the person to ensure the individual's safety during the outing. The facility should have an emergency plan in place if a resident with cognitive deficits becomes lost or confused while outside of the facility. This plan would help manage situations where the individual may need to be safely returned or protected in case of an emergency. Legal consultation and discussions with healthcare providers or the facility's management may also be necessary for specific cases.
While comprehensive statistics specific to assisted living are limited, studies indicate that 40% of individuals aged 65 to 80 are sexually active, with nearly 2/3 of people in this range saying that sex is important to their quality of life. It is not uncommon that relationships, including sexual relationships, may develop between tenants. But what should an assisted living program consider so they're balancing a tenant's rights to autonomy and privacy with concerns of abuse? Let's start with cognition and consent. Tenant rights include the ability to engage in relationships, but this right hinges on the tenant's ability to provide informed consent. For consent to be valid, the individual must understand what they are agreeing to and be able to make decisions free from coercion or confusion. This is particularly complex when tenants have cognitive impairments. It's important to assess capacity thoughtfully, ensuring we respect their autonomy while also protecting them from potential harm. Next, if the tenant has diminished cognition or is a resident in a memory care ALP, reviewing the situation with a physician is key. Physicians can evaluate a tenant's cognitive status to determine whether they can safely consent to a relationship. A commonly used tool is the Mini Mental State Examination, or MMSE, which provides a snapshot of cognitive functioning. This step ensures that any concerns about memory loss, judgment, or other cognitive challenges are addressed professionally. Having the physician involved also provides an added layer of documentation and confidence in the process. Once we've established capacity, the tenant's service plan needs to reflect their situation. This plan should include any accommodations or supports they may need related to their relationship. It's critical to work collaboratively with the tenant and, when appropriate, their family or legal representatives along with the care team. Including these details in the service plan ensures transparency and helps balance the tenant's rights with their safety and well-being. Finally, Iowa Administrative Code Section 481 69.420 requires assisted living programs to have clear policies and procedures for addressing sexual relationships. These policies must cover two key areas. First, relationships between tenants and staff. This ensures professional boundaries are maintained and protects tenants from potential abuse. Second, relationships between tenants with dementia who are at stage 5 or higher on the global deterioration scale. At this stage, cognitive impairments can significantly impact their ability to make decisions, and having clear procedures in place helps protect them. Policies like these should outline steps for assessing consent, handling conflicts, and ensuring all staff are trained to handle these sensitive situations appropriately.
If a tenant with cognitive impairment is identified as engaging in a sexual relationship, the following steps should be taken. A nurse will assess the tenant using a verbal informed sexual consent assessment tool to evaluate the individual's capacity to consent. Additional factors to consider during the assessment include whether the individuals are married, the length of time they have been married or known each other, whether there are negative outcomes when the individuals are together, such as emotional distress, conflict, or other concerns. Second, the tenant's physician will be notified to assist in determining the individual's capacity to consent. The tenant's legal representative will also be informed and is included in the decision-making process regarding the tenant's desire for a sexual relationship. 3, if tenants are found not to have the capacity to consent, the service plan should be updated to reflect interventions designed to prevent such encounters. If the tenants do have the capacity to consent, the service plan will be updated to inform staff of the relationship, outline interventions to ensure privacy, and include steps to monitor for any negative outcomes. 4, the tenant's capacity to consent will be reassessed by a nurse every 90 days or sooner if there is a change in the tenant's condition. 5th, a copy of the capacity to consent assessment will be maintained in the tenant's clinical record to ensure proper documentation and compliance with care standards. Before engaging tenants and answering questions related to sexual knowledge or relationships, it's critical to set the stage appropriately. This ensures that the process is both respectful and supportive of the tenant's rights and comfort. First, staff must explain the purpose of the assessment to the tenant. It's important to communicate clearly why these questions are being asked, to ensure that individuals' needs and rights are understood and respected. Second, the assessment should always take place in a private setting. This not only protects the tenant's dignity, but also fosters a safe and open environment for honest discussion. Third, tenants should be informed that their responses will remain confidential. Reassure the tenant that their answers will only be used to help provide the best possible care during their stay at the facility. Now let's look at the questions themselves. Under Assess Current Sexual Knowledge, we want to focus on 3 main areas. Start by asking, is there someone now that you can talk to about sex? If so, who is that person? This helps us understand if the tenant has someone the tenant feels comfortable confiding in about sexual topics. Next, ask, are there sexual things you should not be talked about? If so, what do you think some of these things are? This may provide insight into the tenant's personal values, beliefs, or discomforts related to sexual discussions. Finally, explore the tenant's understanding of sexual activities by asking, what are some things that 2 people can do together sexually? For example, this might include kissing, touching, or engaging in oral, anal, or vaginal sex. Framing the question this way allows us to gauge the individual's knowledge in a non-judgmental and open-ended way. By following these steps and using these questions, staff can ensure that the tenant feels respected and that we are gathering the information necessary to provide care tailored to the individual's needs and preferences.
When assessing a tenant's current sociosexual issues, it's important to approach the conversation with sensitivity and respect, while ensuring the tenant feels comfortable and supported. These questions are designed to identify potential issues and gain insight into the tenant's experiences and understanding of their own sexual autonomy. Let's go through the questions. Start by asking, have you had sex within the past year? This question helps us understand the tenant's recent sexual activity. which can be an important factor in assessing their needs, relationships, or potential concerns. Next, ask, have you had sex with someone when you did not want to? This is a critical question to identify any instances of coercion, abuse, or unwanted sexual activity. Be prepared to respond with appropriate support or resources if the tenant discloses an issue. Then ask, if you had a problem with someone hurting you or forcing you to have sex, what would you do? This question evaluates the tenant's understanding of how to seek help and whether they know who to turn to in such situations. If needed, use this opportunity to educate them about available resources and support systems. Finally, ask, who do you think is in charge of making sexual decisions in your life? This question helps us assess the tenant's sense of autonomy and control over their sexual decisions. It can reveal if there's undue influence from others or any misunderstanding about their rights. To start, we need to assess whether the tenant has the cognitive capacity to make informed decisions. This is often determined by using the GDS assessment tool. A score of 4 or below indicates that the tenant demonstrates cognitive ability to make informed decisions. However, if the tenant's GDS score is 5 or higher, it's important for the interviewer to observe whether the tenant can still understand the content of the interview questions. Additionally, if the tenant has a guardian and the guardianship paperwork designates the guardian to make decisions about the tenant's sexual behavior, the guardian's approval is necessary for the tenant to engage in sexual behavior. This ensures that all decisions align with the tenant's best interests and legal requirements. Moving on to awareness of sexual acts, we need to verify if the tenant has a clear understanding of the nature of sexual activities. This includes ensuring that the tenant is capable of making an informed choice to either engage or abstain from these activities. Next, we assess whether the tenant understands how to prevent sexually transmitted diseases or STDs. It's crucial that the tenant knows the risks involved and the preventative measures that can be taken to protect their health. Lastly, we address the tenant's ability to identify harmful situations and avoid exploitation. This step helps ensure that the tenant is not at risk of being manipulated or coerced into situations that could harm them emotionally, physically, or legally. By confirming these 4 areas, we ensure that informed consent is ethically and legally given, and the tenant's rights and well-being are protected.
Smoking can be a difficult issue to manage, especially when considering the safety of all tenants and staff. The first step is assessing whether the tenant has any cognitive deficits. If a tenant has cognitive impairments, it may affect the tenant's ability to smoke safely. It's essential to understand how cognitive issues could impair the tenant's judgment and decision-making when using fire-related materials like cigarettes or lighters. Additionally, we must look to other safety concerns, such as the tenant's manual dexterity and mobility. If a tenant has physical limitations like decreased hand strength or limited movement, these factors could increase the risk of accidents while smoking. A thorough safety assessment should consider not only cognitive function, but also physical abilities, dexterity, and mobility. Having a clear smoking policy in place is absolutely crucial. It should specify who is responsible for holding cigarettes and lighters. This helps prevent unsafe behaviors like leaving lighters unattended or placing them in areas that could be accessed by someone unable to use them properly. Finally, it's essential to always prioritize the safety of others. We must consider how smoking may impact the health and safety of other tenants and staff members. Ensuring everyone's well-being is paramount when managing smoking in a shared living environment. By addressing these points, cognitive and physical assessments, clear policies, and safety protocols, we can effectively manage smoking in a way that safeguards all individuals in the facility. Alcohol consumption is actually quite common among residents in these facilities, so it's essential to have a clear understanding of how it is managed. First, we need to consider whether alcohol use is a right for tenants within the facility. While it may be part of a tenant's personal choices, we must ensure that any alcohol use aligns with facility policies, health guidelines, and care plans. An important factor in managing alcohol use is staff training. It's critical that staff members are trained to recognize the signs of alcohol or substance abuse. This includes understanding behaviors that might indicate abuse, as well as knowing how to intervene in a safe and supportive manner. Staff should also be familiar with the protocols for responding to these situations. Another key issue is the interaction between alcohol and medications. Many residents in assisted living facilities are prescribed medications, and alcohol can have dangerous effects when combined with certain drugs. It's vital to ensure these potential risks, or to address these potential risks, and ensure that appropriate policies are in place to minimize any harmful interactions. This might include assessing each tenant's specific medication regimen and developing a strategy for safe alcohol use, if applicable.
Advance directives are legal documents that designate a legal representative, usually called a healthcare proxy or agent, to make decisions on behalf of a tenant regarding their medical care if they are unable to do so. There are three primary types of advance directives that every tenant should be aware of. First, durable power of attorney for healthcare. This document designates someone to make medical decisions for the tenant if they become incapacitated. It's durable because it remains in effect even if the tenant becomes mentally or physically disabled. Living will. A living will outlines specific medical treatments or procedures the tenant wants or doesn't want in the event they are terminally ill or in a persistent vegetative state. It helps ensure that their wishes about life-sustaining measures are followed. Out of hospital do not resuscitate orders. This order provides instructions about what to do in case the tenant experiences a medical emergency outside of the hospital. It specifies that no attempt should be made to resuscitate them if their heart stops or they stop breathing. These documents give clarity and guidance to medical professionals, family members, and legal representatives when important decisions need to be made. As defined by Iowa Code Section 144B, this is a legal document that gives another person, known as the designee, the authority to make medical and healthcare decisions on behalf of the principal. This document becomes especially important when the principal is no longer able to make decisions for themselves due to incapacitation. It ensures that their medical care is managed according to their wishes by someone they trust, providing clarity and direction for healthcare providers, family, and loved ones. In situations where a tenant cannot express their preferences, this legal tool ensures that another individual can act in their best interest, ensuring continuity of care and respect for their healthcare wishes. In Iowa, the DPOAHC does not take effect until a medical doctor confirms that the principal is unable to make their own healthcare decisions. It's important to remember that if the inability is temporary, the authority of this designee may not be invoked immediately. This allows the principal to retain control over their decisions as long as they are capable. Once the DPOAHC, or Durable Power of Attorney for Healthcare, is in effect, the designee's decisions must be made according to the tenant's directions, if those directions are clearly outlined in the document. If there are no specific directions provided by the principal, the agent still has the authority to make healthcare decisions on the principal's behalf. This can include important decisions like withholding life-sustaining treatment if the agent believes that it aligns with the tenant's preferences or best interests. Iowa Code Section 144B.4 is very specific about who is excluded from acting as an agent for healthcare decisions. First, a healthcare provider who is directly attending to the principal cannot serve as their designee. This includes doctors, nurses, or other medical professionals responsible for the tenant's direct care. The reason for this exclusion is to avoid any potential conflict of interest, ensuring that decisions are made solely in the best interest of the principal. Secondly, an employee of a healthcare provider cannot be named as the designee unless they are a relative of the principal. This helps prevent situations where an employee's role in the facility could influence their ability to make unbiased, independent healthcare decisions for the tenant.
A living will is a legal document defined under Iowa's Life Sustaining Procedures Act. Its purpose is to give individuals a way to express their preferences about medical treatment in advance, especially in situations where they are no longer able to make decisions for themselves. Specifically, a living will provides written instructions to medical personnel, directing them to either perform or withhold specific medical procedures based on the individual's wishes. These decisions typically relate to life-sustaining treatments such as ventilators or feeding tubes. It is important to note that a living will only becomes effective when the person is terminally ill and unable to make the individual's own healthcare decisions. This ensures that the individual's wishes are respected even when the individual can't communicate those wishes directly. By creating a living will, individuals can maintain a sense of control over their healthcare, reduce uncertainty for their loved ones, and provide clear guidance to medical professionals during difficult times. First, the situation must involve a life-sustaining procedure. These are treatments or interventions that serve only to prolong life without addressing the underlying illness or improving quality of life. Next, the patient must be determined to be terminally ill. This determination must be made by the attending physician and confirmed by a second physician. Both medical professionals must agree that the individual's condition meets the criteria for terminal illness. So what qualifies as a terminal condition? According to Iowa law, it's either an incurable or irreversible condition that is expected to result in death within a relatively short period of time, or it is a comatose state where there is no reasonable expectation of recovery based on medical certainty. By establishing these conditions, the living will ensures that medical decisions align with the individual's wishes during a time when the individual cannot advocate for him or herself. A DNR is a medical order indicating that the individual does not wish to be resuscitated using CPR in the event of cardiac or respiratory arrest. To be valid, a DNR requires physician authorization. It must be written and signed by a licensed medical doctor. Additionally, the individual or the individual's healthcare agent or the individual's family must approve the DNR. If the individual has a legal guardian, a court order granting permission is also required. In healthcare settings, particularly in hospitals and nursing facilities, CPR is performed by default unless a DNR order explicitly states otherwise. For nursing facilities, not adhering to a DNR order can result in serious survey implications, including regulatory penalties.
It's important to note that DIO regulations do not require ALPs to provide CPR. This means that whether or not CPR is performed in an ALP is typically determined by the program's individual policies and procedures. If your ALP has a policy on CPR, it's critical that these policies are clearly written and specify when and how CPR will be administered. Just as important, all staff must be thoroughly trained and familiar with the policy to ensure consistency and compliance. If a program fails to follow its own CPR policy, this could lead to compliance issues with DIAL, which oversees assisted living facilities in Iowa. Additionally, it could create civil liability risk, particularly if an incident arises where the policy wasn't followed as written. To summarize, while CPR isn't required in ALPs, having a clear and enforceable policy and ensuring staff understand it is crucial for maintaining compliance and reducing potential liability.
So what is iPost? iPost is a standardized salmon-colored one-page document that communicates a person's preferences for key life-sustaining treatments. This includes decisions about whether or not the individual wants to be resuscitated in an emergency, the general scope of treatment the individual wishes to receive, preferences for artificial nutrition, and more. The unique color and standardized format make the document easily recognizable, ensuring it can be quickly accessed and understood by healthcare providers in any setting. The iPost project began as a pilot in Cedar Rapids in 2008, aiming to bridge communication gaps between healthcare providers and to honor patient choices consistently. Based on its success, iPost became statewide in 2012 thanks to legislation. So why is it important? Well, iPost significantly improves communication between healthcare providers, ensuring that treatment aligns with the individual's preferences, even during transitions between care settings. It's an important step forward, providing consistent and patient-centered care, particularly for those with serious illnesses or complex medical needs. In summary, iPost empowers individuals to make their treatment preferences known and ensures these choices are respected across the continuum of care. Assisted living programs may encounter tenants who are unable to manage their own personal or financial affairs. These situations can arise when tenants lack immediate family members or other support systems, or when they face challenges such as cognitive decline, serious medical conditions, or other circumstances limiting their ability to make decisions. To ensure their needs are met, legal representatives or agents may be appointed to act on their behalf. These agents include guardians, court-appointed individuals who make personal decisions for tenants unable to do so themselves. Conservators are court-appointed individuals who manage financial matters for tenants who are unable to oversee their finances. A power of attorney designees who are chosen by tenants to handle specific responsibilities such as finances or healthcare. We'll explore each of these roles in more detail later in the presentation, focusing on their responsibilities and how they support tenant rights in assisted living programs.
Guardianships and conservatorships are legal tools used when an individual, referred to as the protected person, is unable to make decisions for themselves. While these terms are often used together, they serve distinct purposes. Iowa Code Section 633.633 through Iowa Code Section 633.682. A guardian is responsible for making personal and health-related decisions on behalf of the protected person, such as where they live or the medical care they receive. In contrast, a conservator is focused on managing the protected person's finances and assets, ensuring bills are paid and resources are used appropriately. To establish a guardianship or conservatorship, the burden of proof lies with the person requesting the court's appointment. They must demonstrate that the protected person is incompetent and unable to manage their personal or financial affairs. The court then determines the appropriate scope of authority. Whenever possible, courts aim to limit the powers granted to only what is necessary. There are also different types of guardianships and conservatorships tailored to the protected person's needs. In general, this provides full authority unless restricted by the court. In a limited situation, the preferred option, granting only the powers absolutely necessary. In a temporary situation, it would be used for specific purposes or timeframes. Standby, designed to take effect upon a particular event, such as an illness or incapacity. Finally, these arrangements aren't permanent. A guardianship or conservatorship ends if the protected person passes away, if the court determines it's no longer necessary, or if the ward regains the ability to make their own decisions.
A power of attorney, or POA, is a legal document that allows one person, known as the principal, to authorize another person, called the agent, to act on the person's behalf. This typically applies to financial matters and other transactions, and in Iowa, it's governed by Iowa Code Chapter 633B. One key aspect to understand is the concept of durability. Under current law, a power of attorney is presumed to be durable unless explicitly stated otherwise. This means it remains valid and effective even if the principal becomes incapacitated, a critical feature that ensures continuity in decision-making during times when the principal can no longer act for him or herself. Creating a power of attorney involves a few essential steps. First, the principal must have the capacity to understand and agree to the arrangement. The document itself must clearly outline the agent's powers and responsibilities and include the individual's name. It must also be signed by the principal, or in some cases by another person in the principal's presence and at the principal's direction. It's important to note that the agent cannot sign on behalf of the principal during this process. A power of attorney is a versatile tool that can be used in a variety of financial and legal situations. Some common uses include managing financial transactions, handling investment accounts, and dealing with real estate, whether it's selling, leasing, or maintaining property. A power of attorney can also be used to prepare and file taxes, apply for benefit programs like Medicaid, and to pay bills. Additionally, it plays a crucial role in setting up a Miller Trust, which can help someone meet Medicaid eligibility requirements. While a power of attorney grants significant authority, it can be revoked at any time, even if the principal no longer has capacity. This revocation can be made orally or in writing and should ideally be communicated to the agent. If the agent isn't available, the principal can notify a healthcare provider to ensure the termination is recognized. It's also important to think about who should have copies of the power of attorney. The agent, of course, should have a copy, as well as the principal's doctors and other healthcare providers. Trusted family members or friends also should have access to a copy. The document should be easily accessible. It's not helpful if it's locked away in a safety deposit box with no one able to reach it in an emergency. Instead, have multiple copies stored securely, but in locations that can be accessed quickly.
Managed risk policies are essential in balancing risk with tenant autonomy in assisted living programs. According to Iowa Administrative Code Section 481, 69.31, all ALPs are required to have a managed risk policy, which must be shared with tenants as part of their occupancy agreement. The goal of this policy is to promote choice and independence for the tenant. However, this doesn't mean we ignore situations that come with higher risks. Instead, the policy helps ensure that risks are managed thoughtfully, while still allowing the tenant to make decisions about their own care and living situation. In short, while we support autonomy, the managed risk policy also ensures that we address risk in a responsible manner and in compliance with state regulations. Now let's look at the core of the managed risk policy, how it works in practice. Iowa Administrative Code Section 481-69.31 emphasizes a consensus-based process when addressing specific risk situations. This process involves both program staff and tenants working together to identify and agree on how risks will be managed. The result of this collaborative process is a managed risk consensus agreement. This agreement includes a detailed plan for how identified risks will be handled. Signatures from the tenant and all participants in the process, ensuring mutual understanding and agreement. The final agreement must be included in the tenant's file for documentation purposes. The ultimate goal of this agreement is twofold. One, to maintain the tenant's independence and autonomy as much as possible. To identify risks early and manage them appropriately, ensuring the tenant's safety while meeting regulatory obligations. Finally, let's discuss what should be included in a managed risk policy and when it's appropriate to implement a managed risk agreement. A comprehensive policy should outline specific guidelines on when a managed risk agreement is necessary, examples of scenarios where risk management might be required, steps for documenting and implementing the agreement to ensure all parties are clear on expectations. Next, a managed risk agreement is typically used when a tenant's choices or behaviors present a potential risk to themselves or others. When the staff and tenant need to agree on a balanced approach to ensure the tenant can be as independent as possible while maintaining safety and well-being. The policy provides a framework to manage risk without restricting the tenant's freedom, ultimately ensuring they receive the right support in a manner that respects their autonomy.
Well, that concludes our presentation today. Thank you for joining us. If anybody has any questions, please feel free to reach out to us. Our contact information is on the slide. We appreciate your time and attention, and have a great day. Thank you.
Thank you.